Hi, I'm TJ Ryan, ACTEC Fellow from Phoenix, Arizona. And today we present to you Will versus Trust, which estate planning option is right for you. And today, I'm really thrilled to be joined by Tanya Shannara from Birmingham, Alabama. Tanya, what is a will and what does it do?
Hi, TJ. Well, a will is sometimes referred to as a last will and testament, and it's basically a person's expression of their wishes regarding where their assets will go at death. A will allows the testator, that's the person making the will, to name their beneficiaries and to name a personal representative, that's the person that will help administer their estate. And also, if they have minor children, they can name a guardian in their will. A will does not take effect until after a person passes away. So up until that point, you can change your will as often as you like, as long as you have capacity to do so. There's no one size fits all. Every state has their own laws regarding wills, and it's really important that wherever you're located, that you're talking to someone that's knowledgeable about your state's laws on wills. Now, TJ, what is a trust and how does it differ from a will?
It's a great question, Tanya. A trust is a legal arrangement whereby someone known as a grantor or a settlor transfers property or ownership of assets to another party, known as a trustee, who holds and manages those assets for the benefit of a designated set of beneficiaries or beneficiary. Unlike a will, a trust can take effect during a grantor's lifetime, especially in the case of an inter vivos or what we call a living trust, or upon death in the case of a testamentary trust, which is contained within the contents of a will or within the language of a will. Now, a trust, unlike a will, is a private document, and when properly funded, does not need to pass through the probate process. It doesn't have to be court validated. This is one of the most significant practical distinctions between a will and a trust, that a will is a public record once it's admitted to probate, whereas a trust generally remains private. And it's important to note, a lot of people think that trusts are only for the wealthy. You can have a trust that's set up for only $1. And I know, Tanya, you've told me in the past that you guys tape a $5 or a $10 bill to the back of your trusts, right, to fund them?
That's right, TJ. So, are there different types of trusts that we should be aware of?
There are. There's generally two types of trusts that we use in the estate planning world: revocable trusts and irrevocable trusts. A revocable trust is one that the grantor or the settlor can modify, they can amend, they can even revoke during their lifetime. The grantor typically serves as the initial trustee and retains full control over the trust assets during their life and while they're capacitated. Because a grantor retains this level of control, the assets in the revocable trust are still considered part of the grantor's taxable estate for federal estate tax purposes. Now, in contrast, an irrevocable trust cannot be modified or revoked once it's been established, absent court approval or the consent of all of the beneficiaries, depending on the state law that applies. Because the grantor relinquishes control over the assets placed into an irrevocable trust, those assets are typically removed from a grantor's taxable estate, which can provide significant estate and gift tax planning benefits. Tanya, what is probate and why do people want to try to avoid it?
Probate is the court supervised legal process through which a decedent's will is administered. Now, during probate, the court validates the will if there is one, appoints a personal representative, identifies and inventories the decedent's assets. The administrator pays all expenses, debts, and taxes. And ultimately, the administrator distributes the assets according to the will to the beneficiaries named in the will. So, why would people want to avoid it? Well, for several reasons, really. In some states, and I know Arizona is probably one of these, probate can be a pretty expensive process. You're paying attorneys, you're paying court costs, you're paying statutory administrator fees. Now, in Alabama, where I live, probate actually is a relatively inexpensive process, so it's not the end of the world if you have to go through probate. But one of the things that people seek to avoid about probate is the part where it becomes public record. So fortunately, in our state and every will that I prepare, we we waive the requirement of an inventory so that we can keep those assets private. Oftentimes, people want to avoid it simply because it can be a time consuming process. Typically, you have to keep the estate open a minimum of several months. Oftentimes, it takes more than a year. So, lots of reasons to try and avoid probate.
And Tanya, how does a revocable trust help someone avoid probate?
Well, a revocable trust is a way of owning your assets so that they're no longer in your individual name. Instead, they are titled to the name of your trust. And the trust serves sort of as your alter ego. You continue to be the trustee. Typically, you're usually the initial beneficiary. But because the asset does not is not owned by you individually, then it avoids the probate process. And whoever the successor trustee is under your trust simply begins to take over at the point of your incapacity or upon your passing. So it provides a more seamless process and more efficient process for making sure that your assets are going to eventually end up where you want them to go. What's really important about a revocable trust is making sure that you go that extra step and fund it. A revocable trust does you no good if you don't actually retitle your assets and make sure that those assets are owned by the trust instead of you individually. TJ, are there other ways to avoid probate besides having a revocable living trust?
Absolutely, there are. There's several other strategies that can be used in order to avoid the probate process, both independently or in combination with the use of revocable trust. First, assets that are held in joint tenancy with rights of survivorship, tenancy in the entirety, or here in Arizona, where we're a community property state, community property with right of survivorship, pass automatically to the surviving joint owner or spouse, depending on the form of ownership, upon the death of the other owner, passing completely without going through the probate process. We call this a non-probate transfer here in Arizona. Second, there's other types of accounts and policies that allow an owner to designate a beneficiary who would receive the assets directly upon the account owner's death. These include life insurance policies, retirement accounts such as IRAs and 401ks, payable on death or transfer on death, or POD or TOD accounts, and brokerage accounts. So long as there's a validly named and appointed beneficiary on that account at the time of death and that beneficiary survives, then those assets pass outside of probate to that designated beneficiary, whether individually or in percentages or in dollar amounts. I've seen that done as well. Third, some states have adopted transfer on death statutes for real estate. Arizona, we have what's called a beneficiary deed, which allows you to name a beneficiary or a number of beneficiaries to receive your property outside of probate upon your death. The owner continues to retain control during their lifetime, and they can even revoke the beneficiary deed at any time or the designation, depending on how the state employs that strategy. And then a lot of states, including Arizona, offer what's called a simplified probate process or a small estate affidavit. That allows an individual who is the recipient of assets to use an affidavit to collect things like bank accounts and financial accounts and even real estate. Here in Arizona, up to $200,000 of personal property and up to $300,000 of equity in real estate simply by presenting an affidavit to the proper parties. And so while it doesn't, and it may not eliminate probate altogether, it can significantly streamline that process and reduce the costs and associated delay. Tanya, should a client use a will, a trust, or both?
I think they need both. If you're going to have a trust, you also need a pour over will, just in case some assets don't find their way into the trust or you acquire assets after you set up the trust. So a pour over will serves as a safety net. Additionally, there's some things that you could only do in a will, such as appoint a guardian for your minor children. So I like to think about wills and trust as working in tandem rather than as alternatives for each other. TJ, what happens if I become incapacitated? Does a will or a trust help me?
That's a great question. A will provides literally no protection in the event of incapacity because it only takes effect upon death. If a person becomes mentally or physically incapacitated without any other estate planning documents in place, their family is most likely going to need the assistance of a court ordered guardianship or a conservatorship to manage that individual's affairs. Those actions are time consuming, costly, and incredibly intrusive. A revocable living trust, on the other hand, provides a built in mechanism for managing the grantor's assets in the event of incapacity. The document typically includes provisions specifying how incapacity will be determined and then designating a successor trustee who will step in to manage the trust assets if the grantor can no longer do so for themselves. This allows for a seamless transition of incapacity planning for the benefit of the grantor without having the need for any kind of court intervention. For this reason, incapacity planning is often cited as one of the most important but also overlooked benefits of a revocable living trust. It's also advisable to complement a trust with a durable power of attorney, which grants a designated agent, an individual that you appoint, to handle financial matters for the benefit of the grantor of the trust, but for things that fall outside of the trust. Common example is a retirement account that we can't actually fund or transfer to a trust during life. And then also an advanced healthcare directive or a healthcare power of attorney, which allows another individual or the same individual, depending on who you choose, to address medical decision making. Tanya, what are the key takeaways for someone beginning the estate planning process?
The most important part of beginning the process really is finding the right person to advise you. And I highly recommend you find a qualified estate planning attorney that's familiar with your own state laws and start there. Secondly, every adult needs a will. That's sort of the baseline document. But in many cases, a revocable trust is a good idea as well. And it's just part of having that comprehensive estate plan along with those ancillary documents, TJ, that you recommended, like a power of attorney and a healthcare directive. And finally, estate planning is not a one and done activity. It requires attention, it requires review. Anytime there are changes in family circumstances, financial circumstances, and even changes in the tax law, it's a good idea to take a look at your estate plan and see what updates may be necessary.
Thank you, Tanya. That's such a great point. I love to say that estate planning documents are a static response to a dynamic condition. They don't change unless we change them, so it's really important that we review them and modify them as necessary. Well, thank you so much for joining us. If you're interested in further information about the estate planning process, this topic, or other estate planning topics, please do visit actec.org/estate planning for more information.